welcome to Legally Speaking with me, Tarun Nangia. Today, we continue on our part 2 of our series on the Prevention of Money Laundering Act and the defects in that law with eminent jurist, senior advocate, third-time sitting member of Parliament and former chairman of Parliamentary Committee, Dr. Abhishek Manu Singhvi. Welcome, Dr. Singhvi, to this series which we have titled Saturdays with Singhvi. And let us begin our journey on part 2 of our series on the Prevention of Money Laundering Act.
Well, Tarun, you connected with the earlier episode, and since I'd had the privilege of being one of the lead counsel in the Supreme Court bench on that issue, I think you exhaustively covered one issue last time. There are several issues today which could be of interest. Of course, the Act has more issues than this, and you're not really into a technical discussion in that sense. Secondly, as I said at the outset last time also, that we are in a situation of a sub judice active hearing going on. So this is really only a summary of each person's view or submissions to the court. It is not in any manner intended to prejudge a ongoing sub judice issue, which alone the court alone will decide. But one of the other interesting issues I had occasion to argue was the issue of emergency attachment.
Emergency attachment.
Which is, to be technical, Section 5, a second proviso. And emergency attachment is basically a kind of I'm talking of the defects of drafting. It appears to be an open-ended, independent provision, which seems to have no anchor or no rooting with the provisions before and after. It allows for the emergency attachment of any property of any person. Now, obviously, if read literally, it would mean any person and any property would include property unconnected with the main offense or from the proceeds of crime of that main offense. And any person would mean any person who is not necessarily connected with the main offense or with the proceeds of crime. Now, facially, the way it is drafted is a very open-ended thing, and therefore we have said that you have to have a restriction in limiting it to the context of the first proviso or the main section, in which case it will be all right. Otherwise, what happens is, at the preliminary stage, Tarun, there is no real document available, no charge sheet, no prosecution complaint, not even an ECIR, which is the trigger FIR for PMLA offenses. So, you have an allegation of an offense of bribery, and you go and emergency attach a fifth person's property. At that emergency statement, at the emergency stage of attachment, you don't have to show a nexus between that fifth person and the original offense of bribery. You don't have to show how the money has traveled from A to B to C to D and landed at E, whose property you are emergency attaching. So this section will have to be read down, is the point we made. Because otherwise it becomes an independent tail wagging with or without a dog. The main body, it becomes totally independent of. And huge properties are attached on very, very subjective, very, very knee-jerk perceptual thing because an emergency attachment. And therefore, the first part is related to the reading down very strongly and anchoring the second proviso of Section 5. Otherwise, it has the potential for great mayhem and destruction.
If I may ask you to explain with the help of an example, I want to ask you this question. If there is a FIR filed by the Delhi police, then the Enforcement Directorate files an ECIR. After that, can under emergency attachment provision, a property be attached which is unconnected to the proceeds of crime, which means it is some ancestral property or some other personal property which can also be attached?
Absolutely.
Absolutely.
You know, suppose you have property 10 years old. Don't use the word ancestral because that may create comfort. Let's assume you own a property 10 years old. Crime is committed in 2022. That property is with you for 10 years. Maybe your parents are staying in it. Maybe your family is staying in it. Now, in the event of offense in 2022, the proceeds of crime from that offense can only follow after that, can't they?
Yes, of course.
2022 January, the offense is committed. Let us assume the proceeds of crime have flowed in 2022 February or March. And let me assume you catch that proceed or do not catch it. But certainly that proceed of crime can be manifest only in a property other than your 10-year-old property, no? It's
Yes.
common. It
Yes.
cannot. But the ED frequently simply sees a person with property and attaches the property. And later on, you can wait for acquittal, you can wait for denotification, all that will follow. But by then, all the destruction and harassment has happened. They are not relating it to the offense and the proceeds of crime. And that is the lacuna which has to be plugged.
So if I may ask you before we move on to the next point, this is the case of an open-ended law. The law should specify that old properties can't be attached. Is that what you're also in a sense pleading for?
Absolutely. The law should specify, but so long as the law does not specify, because that is the job of the legislature, not the courts, it must be struck down.
It must be struck down.
As being clearly contrary to Article 14, unreasonable, perverse, contrary to Article 19(1)(g), contrary to so many other articles of the Constitution, including 300 capital A, which deals with.
But this was this issue addressed in Justice Rohinton Nariman's judgment of Nikesh Tarach and Sav 2017?
Nikesh is only about the twin conditions.
Only about the twin conditions of bail.
Yeah.
Okay, point very well taken. We'll move on to the issue of possession, which you briefly touched in part 1. You said that ED can take possession. Can you explain it briefly for the audience?
Possession is even more funny, draconian, very, very casually drafted and even more casually applied. Now, many issues arise here. The first point to note is that we are now talking of possession, not attachment.
Okay.
The vast difference, as you know, attachment is on paper. I don't come and take your house. I attach it. In other words, I freeze it.
Yes.
I can understand that, although there are lots of problems. I just given an example of emergency attachment. There are lots of problems that need reform, but I can even understand that because that prevents alienation. The only object at that time rightly should be to prevent Tarun Nangia from alienating. You achieve that by emergency attachment.
Yes.
Or by normal attachment, even non-emergency attachment. Question here is very different. Here, before adjudication, you are not a guilty person, you are not a convict, you are only a accused under suspicion. Before any adjudication, any judgment, how can you take possession of the property after having attached it? You already attached it. So actually the public interest is served to the extent that Tarun Nangia cannot alienate, sell, etc. Now, why should you need to possess the property immediately upon confirmation? You see what happens is a complaint is filed, a confirmation proceeding takes place. Immediately after that, you are entitled to take possession. The adjudication is happening much later, acquittal or conviction will happening much later, even the appeal will happen much later. But on mere confirmation, you can take possession.
So I want to ask you in about 2 minutes, what are the problems that can be caused when the ED has such draconian power of possessing your property?
Now what happens on possession? You will understand immediately. Example number 1, you are living in a house with your aged parents and family. You have to leave.
You have to leave?
Yes, because possession is taken. Second, you have a tenant. The tenant has to be evicted, except with one exception. If the lease, you are living in a state where the lease is registrable by law, and most states in India don't require compulsory registration. But if those which do, there, if it's a compulsory registrable lease, then only the rent will be taken by the ED. Otherwise, the owner and the tenant will be evicted. Now, what is the purpose of that? Zero, because you already attached it. It's safe.
Why do you want to take possession?
Why do you want to take possession? Example number 2. Example number 3, you have shares, because this applies to movable and immovable both. And sometimes those shares may be X%, but they may be vital for a major company. They may turn the voting power this way or that way. The shares stand transferred by possession to the ED. And theoretically, I gave the funny example in court that I, the ED, may use Tarun Nangia's shares to vote against Tarun Nangia in his own company, because I have taken hold of his shares. Now, what on earth should the public interest be in taking it? I mean, I can understand that Tarun Nangia cannot sell his shares, he cannot spirit them away, he cannot transfer them, but that is sufficient by attachment. You don't need to do this. Number 4 example, there is no proportionality. Your proceed of crime or money laundering is 10 rupees. The attachment and more importantly, the possession will obviously be of 1,000 rupees. because you take possession of the house. Now, the value of it
Attachment is far in excess of the alleged crime.
Yes. Example number 5. The whole thing is designed in this way. There is a very interesting rule which says that the value of the attached or possessed property shall be the value as on the date of acquisition. I gave this example of program last time.
No, but
You have
for our
acquired
viewers,
property
let me
5 years
explain
ago.
this.
If you have acquired property 5 years ago for 1,000 rupees, today that property is 10 lakh rupees. The ED will take 1,000 rupees value, not the real value today. So there are
to make it simpler for my viewer, as you said, if you buy a house in Golf Links for 50 crore and now it has become 200 crores, ED will value it only at 50 crore and attach it.
And therefore attach multiple properties because the crime may have involved a proceeds of crime of 100. So they'll attach 2 of your properties instead of half of a property.
So this is in fact injustice to, and in fact, I want to ask you this one supplementary question. This crime has a sentence of 7 years, which is much less than for murder or any other heinous crime. Then when there is no comparison or proportionality in that sense, then why is it treated, in this way?
I call it a hawa. It's not a word which is of law, but this is a whole hawa created. It is meant to be a harassing law. It is meant to be a fearsome law. And much more than the law itself, because 7 years is nothing compared to the life imprisonment and death sentence offenses you have. But the ED has been made into a hawa. It has been made as an institution to create fear. And therefore, this is something which the misuse of the law by such agencies has to be controlled only by the courts.
So before I move on to the next question, let me ask in the form of an anecdote. Against, say, Mohan Lal, a ED case is filed. His house in Golf Links is attached. After that, possession is taken. His bank accounts are frozen. He is put in jail without bail for 1 year. How is he to run his house? Because there are other family members. How will the house
get completed, sir? Bizarre, it gets, as they say, curiouser and curiouser in Alice in Wonderland language. If you're running a factory, the factory is taken over.
Factory is also taken.
Yes, a running factory. Now, the point is, the interest of ED is only that if there are proceeds of crime. Remember, all this is before you are convicted as a convict. Before it is adjudication, you are only an accused. Now, the only object of ED can be that I should not sell off the factory to another person. The only object is not sell off the shares in the house. There is no sense in any event why the safeguards cannot avoid possession, take over, and cause need. What happens after 3 years if you are acquitted? Let me ask you that question. You are acquitted completely, or it is found that this was completely wrong and they release the whole thing. I am saying, I'm going further and assuming they release all your things. Does it, is it a great solace to you, except that you got it back? You have already suffered for 3 years.
And I think the whole business can go for a toss in that time.
And what have you achieved? Nothing, because you are anyway freezing it. You can't sell it. So I don't know what you've achieved. Does this?
And a small question, you mean this attachment can go on till your trial is on, which is for years?
Of course. No, till your acquittal or conviction.
So which means the whole businesses can be ruined.
Yes. Now there is a provision, another point we pointed out, there is a provision that upon a prosecution complaint being filed, which is a charge sheet, this should stop and lapse. But they have a badly drafted clause which doesn't have the phrase whichever is earlier. So we demonstrated to the court that it can actually continue endlessly till conviction or acquittal, which, as you know, can take equally long 6, 7, 8 years.
So in fact, this is a classic case of a defective and a bad law. More than anything, it is badly drafted, it is over-inclusive, it is blanket, and much worse, it is intended to terrorize. And even worse than that, the way in which it is operated is even worse than the way it has been drafted. Now, I want to understand, whenever this news comes out of ED raids, this whole news of search and seizure comes out. Can you explain, is always this search necessary? You go to people's houses?
No, it is not a question of necessary. It is even worse here. Again, it's very interesting and sad and unfortunate. These are sections 17 and 18. One deals with search of the place, one deals with search of the person. Now, the point here is interesting for this reason. The main offense is, let us say, CBI. or the main offense is, let us say, Delhi police. Delhi police could have registered an FIR. So example one, without an FIR of Delhi police, on an information just told orally by Delhi police to ED, there is no FIR yet. ED can enter and search without an FIR in the main predicate offense. Imagine the main predicate offense, which is the dog, is
there is no FIR.
And before an FIR, you can come and search and enter your house instantly. Second example, post FIR, morning FIR is registered. The CBI has not thought it fit to raid you, to search you. But they simply say we have registered FIR, they inform the ED. The ED can come home and search you. It is operated as a totally independent body without any relation and nexus to the main offense. The CBI offense is the main offense. They have not come and searched you, but ED will come and search you. Example number 3, the availability at that time to the accused is neither of the ECIR nor of the complaint. They have nothing. So he simply sits at home and people just enter his house and search everything. As opposed to this, the normal law in sections 93 and 94 of the CRPC is that you have to get a judicial element. The main filter is a judicial element. You must get a warrant from the judge.
There is no requirement of warrant.
Nothing. Third example, there are special acts called Customs Acts or, Excise Act. There, if a officer there of the customs informs the ED that we have found an alleged offense and we are looking into it, on that oral information, again, the ED can visit and search. So ED has become a law unto itself, trigger happy, knee-jerk, and all this can be done before the policeman of the main offense has thought it fit to search.
Now we will go ahead and discuss his wish list of the 1 to 8 or 1 to 7 points in that law, which is called the Prevention of Money Laundering Act, which he wishes to either be read down, struck down, or held unconstitutional, and also the impact on the business community. Dr. Singhvi, how would you like to put your wish list across?
Before I come to that wish list, one last point remains: the reversal of the presumption of innocence. And that is section 24.
So, okay.
And that I'll complete in 2 minutes and I'll answer your question. As you know, the presumption of innocence is the hallmark of Indian jurisprudence, of common law jurisprudence globally. In fact, the old saying, and I don't accept the saying, but it used to be that let 99 guilty people go free, rather than punish one innocent person.
So for the common people, it's you're innocent until you're convicted by the court.
That is the great hallmark, the great foundation of our criminal jurisprudence. What 24 does is, the earlier 24 is even worse. Original 24 says that from beginning, inception, the burden is on the accused. I have demonstrated last time, how will the accused possibly prove? He has no way of proving his innocence because the burden is on him.
And he's in jail.
Now, the amendment says that the burden from the initial stage till the filing of the complaint is on the prosecution. So there is some dilution and some, change in the draconian nature. But from the date the prosecution complaint is filed, which is the charge sheet, till the end of the trial, the burden shifts to the accused.
So basically, you are saying that a businessman who's arrested is guilty until he's proven otherwise in the eyes of the law.
Absolutely. Now, what I did in the argument was to produce a chart. And the chart had offenses like TADA, UAPA, POTA, NDPS, terrorism, narcotics, with life imprisonment and death. Death, mind you. There also they have reverse burden of proof. We are not against per se reverse burden of proof. The point is a little different, that in those draconian reverse burden of proof acts with much more punishment than PMLA, even their basic ingredients of the offense have to be proved by the prosecution. It is not presumed against the accused. For example, in UAPA and TADA and POTA, you have to be first, the prosecution has to prove that you were in the notified area and that there was some explosive found upon you. Then the presumption applies. Here, the basic ingredient of the main offense is put on you, that you, the accused, must disprove. And one other last thing, a lot of these draconian changes have been done by finance acts. This is very, very important, of 2018 and 19 and 16. Finance Act 16, 18 and 19. Now, as you know, that a Finance Act does not get scrutiny in the upper house. because they can at best debate it, comment it, and return it. They cannot object to it, modify it, change it, or reject it. You understand what I'm saying? The Lok Sabha is final. Knowing that it had to circumvent the Rajya Sabha, it is our allegation, and many people have argued it, I also myself have argued it, that this was wrongly characterized as a money bill. The amendment of 16, 18, and 19, which made these amendments to the PMLA. By characterizing it, or rather mischaracterizing it as a money bill, they avoided scrutiny by the Rajya Sabha under Article 110. And there is overarching all this PMLA debate, a matter pending in the Supreme Court, a matter called Roger Matthews, where this objection has been raised that the Speaker's certification was wrongly given as a immunity to prevent Rajya Sabha scrutiny. So to add insult to injury, the PMLA is bad. It is made bad by amendments which have been wrongly passed by avoiding, circumventing, and evading Rajya Sabha. So this being the position, what is the summary of what we've discussed? So we've discussed broadly in these two parts, 45,
which is bail twin conditions,
where clearly it is ridiculous to suggest that Nikesh Tarachand has been revived by the amendment. My wish list is to completely make it clear that this is unconstitutional and the impossibility of getting bail is violative of Article 21. Then we have discussed search and seizure. The wish list there is clear. It must specify that without a predicate offense FIR and without a predicate offense 1, 2, with some judicial filter, only then you can search and seize. Two wish lists under that. Then in 24, presumption of innocence, this must be changed. Some of the essential ingredients must be put on the prosecution to prove. After the prosecution proves A and B, then you can shift the burden. But you cannot shift the entire burden on the accused as is done today. That's my wish list there. Number 4, we discussed possession. I don't think I need to make my wish list clear. You must have a crime, and after the crime, you must trace the money, and then you must relate it to a property, not pre-existing property. You must stop this ridiculousness of treating the date of acquisition as a relevant date. Most important, you must stop this nonsense of taking possession altogether. Have a safeguard. Say attachment, say non-sale, say freezing. But use and enjoyment must remain with Tarun Nangia or his tenant. Why should it shift to the ED? Is the ED a shareholder? Is it in the corporate world they're going to play with your shares? And of course, the last point is emergency attachment, where we have made our points clear that the second proviso alone, and that's I think relatively minor, because that has to be read down to be not independent of the main section to which it is a proviso.
Now, I want to understand from you, in addition to being a third-time parliamentarian, where you take up issues concerning society, various communities, business community, others. So when you look at this law from a parliamentarian's perspective, do you see that if you want businesses to invest in India, this could be something that they could be wary of? That even businessmen who are currently wanting to invest may say, okay, let me invest some part abroad because...
It goes without saying, Tarun, it's not a question of foreign investment. Domestic people are your citizens. Is it correct or is it counterproductive to terrorize your own citizens? You are terrorizing them and you are using it selectively and you are using it very, very discriminatorily. They may not be able to speak up, but believe me, they will think twice. You know the articles published which have said that from 2014 to now, the highest number of people have become HNIs, the highest number of HNIs ever in 8 years have become NRIs or citizens abroad. Is that not clear proof? Forget foreign investment coming, your domestic chaps are going out. Why? Because people want a peaceful life. And in business, if you start digging for the sake of punishing somebody, you will always find something to punish.
Yes. So we've had the wish list from you in these two parts. We've taken everything from twin condition bail to attachment to possession to reverse burden of proof. We have addressed all of this. You also gave me the point that if India wants to grow at 8-9%, it needs businessmen to invest freely, commit investment. Do you think now it has become imperative not only from the legal standpoint, but from India's growth ambition standpoint, to amend this law and all these 8 points to be read down, as in all these 8 sections?
I don't have any hope of that. Let me be very blunt and fact.
No.
My desire is that, but this helps those in power to maintain an element of fear and terror. And I don't expect that the government of the day will want to amend it. That is the way it should be in an ideal situation. But to expect that would be too sanguine, but equally too unrealistic. So it would be a fool's paradise. Therefore, the court should be very clear in either striking down or reading down drastically, and everything can't be read down. Some things have to be struck down. The Nikesh Tarachand court was clear and forthright. And we need that forthrightness from judges who will say this is black, this is white, this is okay, kosher, this is bad. And unless they strike down, some things can't be read down. Some things, of course, can be read down, like Section 5, I said, or some other things. There should be, therefore, a clear combination of both. Misuse of the PMLA cannot and should never be ignored, avoided, or soft-pedaled by any court. Misuse of the PMLA, both in its architecture, in its language, in its structure, in its drafting, and much more so in its use. See, there are cases where the architecture and drafting is okay, but the misuse is there. But this is a strange act where the very architecture is bad, and then the misuse is much worse. So therefore, the courts should come down heavily, and the courts should strike it down. Occasionally, of course, they may read it down, and they must send a clear message that, look, it is not an instrument of terror.
Point very well taken. So with this, we finish our part 2 of, in a sense, highlighting the defects in the Prevention of Money Laundering Act. This was a special 2-part series in our Saturdays with Singhvi that we do every Saturday. I thank Dr. Singhvi not only for making time, but highlighting so many things in this law, which we never imagined. We always spoke only about the twin condition bail. That is what we did so many shows on also. But you brought to light so many more defects: attachment, position, reverse burden of proof, and the way you explained it for the audience. I indeed appreciate your time and also the way you put it forth. I'm sure this will be very useful for the viewers and also for people who are looking and wanting to unjat, be it businessmen, be it chartered accountants, all of them looking forward to it. Thank you so much, Dr. Singhvi, for sharing your time and sharing all this with us. Thank you so much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.